wherever you are in the country on this sunny but also very humid June afternoon. My name's Ed Lewis. I'm the lead partner for specialty insurance at Watemans, and we're delighted that you've joined us for this, the second live question time event in our campaign, dedicated not just to exposing and explaining the many faces of coronavirus and COVID-19 for the insurance industry, but also to helping insurers, brokers, and their customers navigate the challenges posed by the pandemic. We come into today's session with the world struggling to adapt to what is affectionately being termed the new normal. But is it really anything of the sort? Over recent weeks, civil disruption and gloomy economic forecasts have featured daily alongside continuously evolving rules on COVID security, a sharp rise in the registration of claims management companies, and the ever-present threat of a second wave of infections. As the UK High Street reopens and many people return to work for the first time since March, it's hardly surprising that business owners, employees, and insurers alike are apprehensive. So today, we're going to be examining what lies ahead for businesses and their staff, as well as the uncertain profile of the country's economic recovery, with the probability, sadly, of widespread business failings, rising unemployment, increased claims frequency, and fears over the intervention of regulatory bodies. We'll also be looking at how all of this impacts upon insurers, their products and supply chains, the needs of insurance buyers, and trends in claims. In particular, as a point of need product, I'll be asking our panel, can insurance continue to meet the needs of policyholders in modern times? And what should be done to preserve customer confidence and the reputation of an industry poised at perhaps the most significant fork in its path in its 350-year history? Government's role will also be high on our agenda today, but with polls suggesting trust in the Prime Minister has plummeted over his cabinet's handling of the public health emergency and talk of an inevitable public inquiry, all at the same time as negotiations with the EU are about to be thrust back under the spotlight, with only 6 months left to secure a trade deal and avoid the hardest of hard Brexits, what support from Westminster can insurers realistically expect? Now, just a couple of housekeeping points before I introduce you to our panel today. Firstly, because we're broadcasting live as well as recording this event, we shall be observing anonymity at all times. Please be assured, therefore, that we will not associate any of the questions raised with any individual member of our audience. Secondly, if any of you in our audience have technical difficulties during the broadcast, please use the chat message box to contact our marketing support team. They're on hand behind the scenes, ready to help you out. And thirdly, due to the fact that we have about 200 people in our audience today, it's not going to be possible for everybody to raise questions of the panel directly. So I would ask you instead, please, use the question box function, which should be to the right of your screen, if there's anything at all that you'd like to raise. We've got a production team ready and waiting to process all questions, and we'll do our best to answer as many of them as we possibly can. We've also had a great many questions sent in to us already as part of the registration process, and for today's purposes, therefore, what we've done is go through those and drawn out the most popular, the most commonly asked, and those will be the ones that I intend to put to the panel first. And finally, I also need to mention that following on from this event, we'll be producing a white paper, just as we did after question time 1, and it's going to draw together all of the key issues and all of the perspectives of our panel in one place for your review at your leisure after this event. That white paper is going to be available for download on our Coronavirus Hub, and there's also going to be social media posts with links to it as well. So please do look out for those. Okay, so without further ado, let me introduce you to our panel this afternoon. Firstly, we're delighted to have returning after question time 1, Sir Bob Neill MP and Chair of the Justice Select Committee. We're also delighted to have Mark Shepherd, Assistant Director and Head of General Insurance from the ABI. And the ABI, of course, are very kindly partnering with us on this event, which is fantastic. And then we have 3 of my partners from Watemans. Firstly, Deborah Edwards, a partner specialising in disease claims. Dowie App Thomas, a partner specialising in regulatory matters. And Henry Birmingham, a partner and public authority specialist. So let's crack on, get straight into the questions. Here we go. So From an employer's perspective, return to work really does look like a minefield. What's the best advice for a business looking to navigate the myriad rules on COVID security, especially the latest social distancing parameters announced this week by the government? And how can business owners achieve peace of mind that their workplace is COVID secure for staff and customers? Dowie, as a regulatory specialist, I think I'm going to come to you first on this one, if I may.
Thanks, Ed, and good afternoon, everybody. Well, this really is the question, isn't it, right now for businesses and duty holders and employees who are being asked to return to work around the country. Undoubtedly, there are a minefield of rules, recommendations, guidance, and warnings if you don't get things right. I think it's probably sensible, Ed, for me to start with just a summary of where we are currently at. And now that was different to last week's presentation and will be different to next week's presentation. So let me try and accurately summarise where we are in terms of the law. The law in England as regards health and safety in the workplace has not changed during the pandemic. The only thing that's changed in England is some public health legislation, but the health and safety legislation that covers workplace risks has not changed. I say that specifically in relation to England because in Wales, they have changed through their devolved powers one piece of legislation which affects employers. And they, a number of weeks ago, enacted a public health regulation to enforce social distancing in the workplace. So it is law in Wales for employers to ensure social distancing in the workplace as far as they reasonably can. There is no such similar law in England. Okay, challenge number one, especially for those organisations that might have sites in both Wales and England. But just to show how much of a game changer COVID is as we return to work. In 2003, the government and the Health and Safety Executive looked at infections at work, and they produced a paper called Infection at Work, Controlling the Risk. And in one of the earliest paragraphs in the document, it said this: although your employees may well pick up infections from workmates, just as they might from their friends and family outside of work, these infections are not your responsibility under health and safety law. That was in 2003. That has not been revealed or revoked, and it has not been amended even during the pandemic. So that was the HSE and the government's view back in 2003. That goes to show what a game changer coronavirus is. It is being seen as a workplace risk, or at least a risk in the workplace, and those two things are different and distinct. Undoubtedly, the government are expecting laws to be enforced around return to work and safety in the workplace, and to support that, they've given, fair play to them, a lot of guidance to industry and businesses around what a safe return to work looks like. At a very high level, they've given 5 steps to returning to work. First and foremost is carrying out a COVID-19 or COVID secure risk assessment. That is step number 1, and I'll talk a little bit about that more in a minute and give some practical tips. Number 2 is allow for welfare facilities, so cleaning and hand washing and hygiene procedures like you've never seen before in the workplace. Thirdly, allow people to work from home wherever they can, and if that's not possible, fourthly, maintain the 2-metre social distancing rule, which is still the standard to be expected. Finally, if people cannot be 2 meters apart in the workplace, you have to try and mitigate that risk as far as is possible. And it gives 6 bullet points for guidance as to around how that could be done. That is where we're at, but it all starts with the COVID secure risk assessment. I'll give some tips about that in a second. But if I could just reflect for a short period of time on that guidance. Clearly a lot of work has gone into that, and it does support businesses to some degrees. There are still, I think, significant challenges for the government to overcome to properly support businesses looking to return to work. There is a complete absence of advice on PPE in the 5 steps to returning to work. Even where the social distance 2-meter rule cannot be enforced, there is no recommendation or guidance around whether PPE should be used or not. Now that's difficult because employees going to work are expecting PPE, not least because if they travelled on public transport to work, they would have had to have worn PPE on the bus or the train on their journey in. And so they then have to remove that, or they might remove that in the workplace. And that's going to put a conflict in the employee's mind straight away. So that's a challenge, I think, that the government and the Health and Safety Executive need to overcome and support the business better. The guidance also talks about doing everything practical, and that's a specific phrase used by the government in their 5 steps to returning to work. That has no legal standing whatsoever. That is a higher standard that's expected in the law, which requires reasonably practicable measures. And again, I think that's dangerous. It's aspirational, it's not legal, and it's unhelpful to businesses. Behind all of this is a threat by the HSE to enforce businesses where they are falling short of the standards expected. I know later on we'll talk about how the HSE may go about doing that, so I won't deal with that now. Let me lastly just give some practical tips for businesses who are going through the return to work phase. What they have to do to be compliant with the law and the guidance is, first of all, know what the guidance is specifically to their sector and segment. Armed with that, undertake a risk assessment. And our risk assessment is a process. It is not just a document. It will end up in a document, but a risk assessment is a process and should be seen as a process, not just a document. Consult with your workforce like you never have done before. They are the biggest stakeholder involved in the return to work phase, and you have to get their agreement to the control measures that you're putting in place. If they tell you something isn't working, listen and revisit your plans. Make them aware of what you're doing, train them, and if needs be, enforce and discipline for breaches of the rules. And keep a document trail. I know Deborah will talk about this because there is a threat of litigation at large, of course. You need to keep a very clear document trail with date stamps, because what you did in May will be different to what you do in June and will undoubtedly be different to July, August and September onwards. So a final comment from me, Ed. We don't know what COVID secure looks like yet. It is new. There is no precedent. And despite my own doubts about there being the correct legislative framework in England around return to work, businesses need to make sure that they undertake a risk assessment and that they engage as best as they can with their workforce.
Thanks, Derek. So some really good tips and good advice there, but also real cause for concern that a lot is being said about COVID security, but actually we don't know what that looks like. And this point about PPE keeps coming up time and again. I mean, the fact that it doesn't feature at all in the guidance to businesses at this important stage in the pandemic, frankly, there are no words given what's been said in the press about that. So Bob Neal, can I come to you on the PPE point? I said we'd pick this up in a moment or two, but we might as well deal with it head on now, if that's okay.
Yeah, it's a big challenge, let's be honest with it. And I would be surprised if every bit of the legislation was absolutely right at this stage. And I do think we're going to have to scrutinise it very carefully. All governments having to grapple with this. I think there will be issues that will come out on this. I think Darry's advice is very sensible. There is going to be a debate, in fact, with the planning, the business and planning bill, which is being introduced into the House. It's been introduced to have all its stages on Monday. There's an opportunity, I think, to ventilate some of these concerns. And what I'd say to any of the people on here, you've got time to email your own MP if you've got specific concerns around that. We'll be taking the committee stage and report stage all on the same day. A lot of it will actually no doubt be done by way of regulation. So there is time there to put pressure on that. But I accept the point. This is completely new for everybody, and we're having to go at pace. And it's that difficult trade-off. Do you wait until you've got everything? To all the I's crossed and T's dotted, whatever. Or do you try and move on as quickly as you can, mix your metaphors up, or do you try and deal with this real pressure to get business moving as much as you can?
But it's commentary on PPE, Bob. I mean, that just seems like a manifest failing on government's part as far as the new guidance is concerned. I mean, you would have expected at least some reference, some guidance on the use of PPE, its availability, particularly in certain sectors, certain industries, surely.
I've no doubt there will be probably more guidance to come down the road on this. I think this is the first initial bit that we've got. Actually, when you look at some of the briefing documents, sadly, the evidence and the scientific basis varies to some degree. It's not as if we have one settled piece of knowledge. So again, there will, I think, have to be a bit of learning as we go along. But it is a really important issue, and not just in this respect. It's going to crop up in relation, no doubt, to any inquiries later on as to what happened with the provision of PPE as well, which is the other really major factor.
Yeah, and just to be clear, we're talking about PPE here outside of the healthcare sector. I mean,
that's right. Yeah.
In healthcare is well understood, but we're talking now about
it's outside.
Yeah.
I've found a lot of people I know, I just want to say, actually taking a fairly cautious approach, and employers providing PPE anyway. But I totally get the point. And again, that's where get lobbying your own businesses, your own MPs, about what specifically is the sort of guidance you as a sector need, because it will probably need quite a variation across the piece. It's not lacking in detail, but are bits missed out.
Okay, thank you. Let's move forward. Gary, if I can come back to you, moving on, the other side of the coin that you were talking about, of course, is enforcement. But I think a lot of our audience would want to know, how practicable is enforcement really going to be? And will it be possible for Boris Johnson to make good on his promise to deliver effective enforcement when regulators like the HSE are known to have significant resourcing challenges already? And will we see a priority focus on certain sectors, industries over others? And how is that likely to translate in terms of staff customer behaviour towards the new rules? And I think also, and this is where I'll bring Bob Neal back in if I may, how realistic is it to think that we can avoid a second wave of infections and a return to lockdown later in the year?
Ed, shall I start with the enforcement piece?
Yeah.
Sure. Okay. So the audience are going to want to avoid enforcement wherever possible. And the best way to do that is follow the guidance. And if you're following the guidance, you're almost certainly free from the risk of enforcement. I don't remember, HSE and local authorities both enforce different types of sectors, different types of workplaces. HSE have had a cash boost from the government, so they've had a £14 million cash boost specifically for enforcement of the return to work phase. Okay, now let's remember the HSE are a regulator. That's what they were created to do, to regulate the industry. They are not primarily an enforcer. However, because of the cuts within the HSE and the fees for intervention regulations that came out a few years ago, they have naturally moved into a space of enforcing rather than regulating, which is a great shame. And what I hope in this pandemic period is that the HSE, who are currently hands-off on enforcement, will maintain that stance, but will move forward with regulating and supporting businesses. So what I hope to see is that £14 million actually put into business support and regulation as opposed to enforcement. How will HSE go about enforcing? What they've said is, if they are concerned that businesses are not complying with the guidance and are risking unnecessary exposure to coronavirus, they will use their enforcement powers via notices. They will not move straight to criminal prosecution. They will use their intermediary powers of issuing improvement or prohibition notices. Now, prohibition notices can close businesses down for a short period of time, so they are a powerful statutory notice that the HSE can use. They will only move to prosecute, they have told us, if they find repeated breaches of those notices. So there's a couple of stages for businesses to get to if they're really falling short before they are threatened with prosecution. I think the HSE are saying and doing the right thing at the moment, which is being hands-off with enforcement, allowing the economy to restart, allowing duty holders to understand what COVID secure looks like and understanding they won't necessarily get it right first time, and having some sympathy for businesses. Sadly, that will wane as time goes on. And as we learn more about what a COVID secure workplace actually is and what it looks like and what it feels like. But what I would say finally is I would really like HSE to look to support businesses rather than sitting in the background waiting with a threat of enforcement. Only go after those that are truly falling a long way short of the mark. After all, Ed, prevention of spreading coronavirus is better than cure.
I mean, I think it's fair to say that there's a degree of latency, isn't there, in the new rules, Gary, and there's a time of adjustment. So you would expect perhaps a softer landing, but as time progresses, and particularly if we see this second wave that's being talked about, probably expect a harder, more robust stance to be taken at that point.
I think that's absolutely right, yes. And if businesses haven't learned first time, they will be given some time, but that sympathy will go and the enforcement will come later in the year if, heaven forbid, there is a second spike.
Okay, so on that very point, Bob Neal, I'm going to come back to you if I may. Whilst not said expressly, I think many people could be forgiven for when reading the new government guidelines this week and hearing the Prime Minister's statement that the government has now resigned itself to a position where there just has to be an acceptable death rate in order to protect the economy. Are we in that position, and do we think that it's realistic to avoid a second wave of infections, particularly after the scenes that we saw in the news yesterday? Hundreds, thousands of people on beaches up and down the country.
Well, let's deal with the second point first. Our own individual responsible behaviour will have a lot to do with that, and some of the scenes were bad. I've had some in my own constituency, in suburban London, where we've had to put in a dispersal order, where people have been out drinking in some of the open spaces. So yeah, there's an issue, but there's the other side to that. There undoubtedly is a risk of a second wave, and that would, of course, bring the risk of death. There is, and it's becoming increasingly apparent, I think, to virtually all my parliamentary colleagues from our postbags, and also ongoing risk of death as well as economic damage resulting from a prolonged lockdown of the kind that we have had. The instances of mental health referrals already seem to be increasing. The real concern I've had expressed to me by clinicians in my area about people not taking up medical appointments, sometimes potentially grave conditions that they haven't done, and of course the need to fund whatever the necessary remediation measures are to deal with the pandemic. So it's a really hard call, Ed, really tough call. Government is about balancing priorities at the end of the day, and so I think they're attempting rightly to be cautious. We've got to be flexible. I think if there were a second spike, would that be a national one, or is that perhaps more localized? Certainly some evidence suggests that elsewhere where it's happened, rather than going back to a blanket lockdown, they've, where possible, done it on a more localized or regionalized basis. So I think that would probably, my if you like, hunch is that that's the sort of way government would prefer to go, rather than a total lockdown, and it might again be more sector specific depending upon the nature of where the transmission is and so on.
Okay, thank you, Bob. Thank you. Moving on to our next question. I'm going to bring here from the ABI. Hopefully we've got Deborah back. We can have some perspectives on claims and a public authority focus also from Henry. The broad question is this: with the current lockdown easing, there seems to be a perfect storm brewing amidst the growing complexity of the new rules on the one hand, the inadequate policing of those rules and the public's propensity to bend whatever rules have been set in any event, not to mention that many medical experts are saying the easing of restrictions on trade and free movement of people have been brought in too soon. We're also seeing an increase in the registration of claims management companies, which is a real cause for concern. So against this backdrop, is the insurance industry concerned about the potential for COVID-19 related liability claims to spike? Mark Shepherd at ABI, can I come to you on that one first, please?
Yes, hi Ed, hi everyone. Great to be involved. I think there is certainly the potential for significant claims that will impact on insurers, in employers' liability and in the public liability markets. So there is some real concern there. But I think there is some important context to this. Firstly, there are still a lot of unknowns. So unknowns around the medical effects, unknowns, as Daria has mentioned, around enforcement and how that will work, and unknowns in terms of treatment within the courts. And then secondly, I think the important context is that this is likely to impact sectors of the economy differently. So the primary concern for insurers at the moment are sectors where people may not have been able to access PPE, or that PPE may have been inadequate in protecting them. So care homes, for example, are a significant concern for the market, but also other areas as lockdown restrictions ease, so transport providers, hospitality, retail and leisure, where social distancing may be difficult to implement or control. I think concerns will start to grow there and the potential for claims are significant. But broadly, I think the impacts are likely to manifest in employers' liability and public liability claims linked clearly to fatalities and long-term physical damage for those, lung damage for those that have been severely affected by the disease. But as I've said, the understanding of the effects of the disease is still evolving and unknown, so concerns might increase or they might diminish as that understanding develops. And Ed, you mentioned CMCs, and I think that also gives cause for concern around the potential for claims, particularly in areas like a loss of sense of taste or smell, chronic fatigue, and psychological effects as well. And when I say psychological effects, I mean both in terms of someone who may have tested positive and is affected by what this might mean for them in the future, what that might mean for their future lung condition or their ability to withstand future lung conditions, but also the worried well, so people going back to the workplace and the stress and concern and fear involved around being part of a workplace where you could be exposed to a serious disease or illness. So I think all of that is culminating in a concern for insurance markets across a range of sectors, but it's not the same across all sectors.
Okay, thank you, Mark. That's really helpful. We're still having some technical issues with one of our panelists, with Deborah. So I promise we are going to come to claims hotspots very soon. We're looking at whether or not we can solve those tech problems or bring somebody else onto the panel instead. But in the meantime, Henry, I'm going to come to you if I may. And there's a question in particular, I think, which everyone's keen to understand the answer to. And what approach can be anticipated from the courts? And will they make a distinction between public sector defendants, corporate defendants, or even corporate or private sector defendants operating public sector services? And how is the balance of risk factors going to be determined in your view?
Before I turn to that, Ed, I think I can probably help you a little bit with hotspots, because we are already starting to identify vulnerable industries, aren't we? We're seeing the meat packing plants. We're seeing people who drive buses, work in transport, being vulnerable to it. So we're seeing where the incidences are. Obviously, people who work in COVID hot zones, hospitals and the like, are likely, these are the places where we are going to see the sort of initial runs of claims. But there's the point that comes out of it in terms of hotspots, which will be claiming hotspot, and Mark has already made mention of care homes. And there is an emerging story coming out of, oddly enough, it's Sky that seems to have been reporting it, but there is an emerging story, an emerging narrative about the discharge of patients from hospitals to care homes. So what the allegation is, what the reporting is that patients have been discharged from a COVID hot zone, a hospital, into a closed community, a community where people don't go out, a community where people live in close confinement and have their personal care attended to by the same people. And that's the discharge of people from hospital, either untested or COVID positive, into care homes. Now, that little group of cases is one that we think that the claimant world will be interested in, because it deals with some causation problems. When we started looking at these cases, looking at COVID-19 and its possibility for case law, one of the first things we thought was that these are going to be difficult cases for claimants to prove. If there's a disease generally prevalent out there that millions of people have had, how do you prove you got it at work? How do you prove you got it at school? How do you prove you got it in a playground, or what have you? So a shop worker who traveled to work on the bus, did they get it at work or did they get it on the bus? But when we look at the discharge of hospital patients into closed communities, so people from a COVID hot zone into a closed community, if there was no COVID-19 in that closed community before the hospital patient was discharged, but there is after the hospital patient was discharged, particularly in the vicinity of that resident's room, then those are cases that start to look pretty good for claimant solicitors on causation. So we think that there could be quite a lot of activity around that. Now, there are all sorts of estimates wandering around between 5,000 and 10,000 people who are said to have died in a care home setting. Those numbers times the possibility of an inquest each, times the possibility of the claims, start to become a very significant hit for a sector and for the insurers. And this, oddly enough, it brings in the point about whether public and private sector defendants will be treated differently. A public sector defendant is, of course, subject to the Human Rights Act. Included within that is Article 2, the right to life. The state cannot act contrary to the individual's right to life. So in situations where there is a real and immediate risk of death that has been caused by the state's action or inaction, claimants can bring proceedings. Now, the point about the Human Rights Act that will be particularly appealing for claimant representatives is that you do not have to establish causation in a human rights claim. You just have to establish breach of the human rights, and then you get the just satisfaction award that flows from that. So we think that claimant lawyers, claimant law firms will be looking at this. I mean, this is a sector that has contracted in recent years because of reforms. So there are people out there looking for things to do. We think that they will focus on the care home sector, and to the extent that private organisations are providing a public function, or that we are dealing with the death of care users, we think that there will be a renewed interest in Article 2 of the Human Rights Act. So plenty of opportunity for claimant law firms and plenty of opportunity for activity here. That's what we're projecting.
And so the claims under Article 2 of the Human Rights Act, Henry, I mean, they're not unheard of, and we've seen them before, but are we expecting to see a more systemic wave of such claims given what we've seen with COVID-19?
I think that whenever you're dealing with anyone providing a public service, the Act is engaged. As a claimant lawyer, if you're bringing a claim, and you can bring a claim in common law negligence and under the Human Rights Act, you will bring it in both. You'll bring it in both because that maximises your chances of winning, and we've seen that phenomenon all over abuse cases, abuse litigation, sexual abuse litigation, following a case called CN and GN versus Poole Borough Council. And we've seen a shift of emphasis where common law claims have become more difficult. We've seen a shift of emphasis by claimant solicitors towards using the Human Rights Act. And I don't see any reason why that phenomenon will not be seen here.
So in terms of the attitude of the courts then, what do we think the reaction will be? Are we going to see a similar approach to the one that we were chatting about in the regulatory context with Dowie, a softer landing perhaps, or are we going to see a harder line taken? What's your view on that, Henry?
Well, I think the first cases will find their way into county courts next year, and they will arrive in front of county court judges. And depending on your view of how the system works, I think a county court judge is going to be pretty sympathetic to a hypothetical nurse who was working in ICU without PPE. I think a county court judge will be sympathetic to key workers who did not have the equipment that was required. So I can see sympathy there. How far that sympathy will go, and whether it will extend to, for example, a worker who travelled to work by bus and who was married to a key worker and consequently potentially exposed at home, whether that sympathy will go that far to start to interfere with law on causation is going to be interesting to see. But the reality of it is that I think a lot of these claimants are claimants for whom the courts will have a significant measure of sympathy. There's also the question of developing knowledge amongst defendants as well. We're all on a journey with this disease. We've all been learning, and you can see how central government advice has changed over the course of time as we've learned more about the disease, its effects, how to treat it. And so I think we as defendants need to make sure that we advance almost a Boland style argument that the precautions we took at any particular given moment were the best of the knowledge as at mid-March 2020 or mid-April 2020 and so forth.
Okay, that's great. Thank you, Henry. I think we may have Deborah back, but we'll move on with the questions, and hopefully tech issues resolved. We'll bring her in shortly. But I want to pose this question next, if I may. In light of what we've just heard, what work is the insurance industry doing with liability insurers to consider these issues? Is government concerned And should legislative reform be on the cards to protect defendants, perhaps in the form of a redress scheme, tariffs, or maybe even wider intervention in the claims process? Mark, the ABI, can I come to you on this one first?
Yeah, I mean, firstly, I think I would emphasise in terms of what the insurance industry want or are calling for, the importance of what Dari has said around clear guidance from the government for employers on their responsibilities. I mean, that's massive to get that right, I think is the first line of defence. And it's clearly the best means of defence to mitigate against this risk as far as possible. So key is really clarity for businesses on what their duties are. I mean, clearly we are working with insurers to raise awareness of how claims may start to manifest themselves. And so that should help them consider how best to work with their customers on risk management as well. And I think that's an important part of the process. Aside from that, I would say, any legislative reform to protect defendants is generally going to be difficult to achieve. I think we should be open about that and not shy away from that, and potentially contentious. But saying that, there are some important considerations. I think a simple one, or potentially simple one, could be, government has already stated its intention to raise the limit for fixed recoverable costs in EL and PL claims up to £100,000. So, we as the ABI would like to see that implemented as soon as possible. And that may help disincentivize some of the potential CMC activity or claims farming activity around some of the potential more moderate or smaller cost of claims. However, I think we very much acknowledge that for some of the higher risk sectors that we've talked about, or where there are sectors where there are much more systemic challenges and where market dynamics are potentially already shifting for very rational reasons, that kind of small change in the fixed recoverable cost limit is unlikely to go far enough. So I think that then comes down to whether government is sufficiently concerned about the ability for insurance markets to continue to effectively provide for these higher risks or systemic risks within these sectors. And then I think that's when it's worth starting to consider whether the threshold for negligence is high enough, whether tariffs for COVID-related claims may be appropriate, although we've seen in other areas, such as whiplash, how difficult those are to achieve and implement in a meaningful way. Or ultimately, I suppose, whether the government plays a role in indemnifying losses in the future if the market cannot. Now, do not get me wrong, none of these are very attractive to argue for and are probably a last resort. And we would be very aware of the reputational concerns around doing so. But it is also worth, I would say, considering that exposure here is not just going to be an issue for businesses and insurers, but for the state as well. And so that might be more of an incentive to look at some of these more interventionist areas. But that's probably one more for Bob.
Okay, well, before I come to Bob, I'm going to come to Henry, because you touched on a point there, Mark, which kind of raises the question that some people have come to us about already, and that is, are we in a situation where a redress scheme would be an appropriate approach to adopt? Henry, what are your views on that?
It's interesting, isn't it? 50,000 dead. In theory, that's the potential for 50,000 claims, millions infected. Some symptomatic, some not. Again, big potential. Redress schemes are attractive to insurers and to governments because they're certain. You set a fund and it's certain. They're attractive to claimants because you merely have to demonstrate that you had COVID-19 and some limited effects. There are no trials, so that there tends to be financial certainty for the payer, and coupled with an ability to get to a conclusion quickly and to get a payout for the person who's looking to claim from them. And there's been some attraction to using them in the context of abuse cases. So we have the Lambeth scheme in respect of the Shirley Oaks Children's Home. There was an Irish abuse scandal, Irish abuse scandal redress scheme. The question in looking at redress schemes, of course, is that they cannot be insured. So from that point of view, a defendant can't claim an indemnity in relation to what they have to pay under a redress scheme. And as always, the difficulty is getting the balance right. Do we set the bar high enough to make sure that we compensate those claims that should be compensated? Do we make sure that the awards are not so high that they wind up costing significantly more than first anticipated or budgeted? And it is a balancing act. And it's a balancing act which, of course, has to be tested in front of the public. And I think, as I alluded to with judges and their sympathy for the fictional nurse who had no PPE, the public has a lot of sympathy for key workers. The public has a lot of sympathy for people who have been caught up in this. And how we balance a redress scheme would be a very, very difficult thing to do. That said, I think it would be able to, it would give significant comfort to the markets, because the markets would be told, local authorities, insurers, NHS, central government, etc., would be told, this is the bill, and that's it. And that would have some significant measure of attraction to them. I don't know what Mark's view on that might be.
Well, Mark, immediate response on that point from Henry before I go to Bob Neal?
I mean, I think it is probably one of many routes to consider and models to consider. I can see, you know, the risks associated with it, given both businesses to some extent and insurers are arguably on the hook for this and should be from a contractual point of view. And I also don't know if it would really help solve the problem for future viability of markets and cover. So clearly, you know, under any redress scheme, there would still be a significant loss for the industry, and not a potentially, in some sectors, definitely not all here, but in some high-risk sectors, potentially not a particularly attractive market to be covering in the future.
So, Bob Neal, a degree of attraction in having a finite amount of redress. You heard from Henry there. What's government's view?
There isn't a fixed view, I think, at this stage. I think it's something that has not actually been greatly discussed in political circles, interestingly. Again, one of the things one has to remember about politics is very much of this is done on a day-to-day basis. And it's sort of dealing with the immediate. Perhaps it's maybe a flaw in our political system, but that's a reality of it in truth. And so they'll be dealing with the immediate problems. And that's why, for example, in its a limited way, the fixed recoverable cost something changes are something I think that you might well see push forward, because that's easy to implement and it's there. Something that has to be designed with some careful calibration and may then need to have a sort of proper legal basis to introduce it. It's not something I think they'll be looking to do in a hurry. It is not impossible, because I do know Treasury and other parts of government are concerned about the sustainability of some areas of the market in terms of insurance. COVID is the obvious one, but there are other concerns. Things have come up, for example, around Grenfell type cladding and insurance around there with the EWS scheme. So they are alert to it on a sort of sectoral basis. And I don't rule that out, but it would be something that I think they'd be wanting to keep it as limited as they can because of the risk of cost overruns. But it's not impossible. I think that and the fixed recoverable cost point are probably the most likely areas of intervention. And you're right, if you were going to prioritise, I suspect they would take a political call which tended to look at those sectors where people are likely to attract the greatest public sympathy, to be blunt. But to do it, you would need the cooperation, not just to a degree of the opposition. I mean, the government has a large majority, but even large majorities aren't certain. And if it required primary legislation, you'd need to be able to get it through the House of Lords in reasonable time. And realistically, there is no legislative time for anything until we get into the autumn, because that's booked through on Brexit related and other things. So, you know, it's don't rule it out, but I wouldn't be looking for that as the cavalry coming anytime soon, as far as that's concerned.
A couple of points on that. I mean, you make the point there, Bob, that there's no Parliament time left until the autumn, but how realistic is it that we're going to see any Parliament time in the autumn free in any event, given the very hard deadline as far as negotiations with the EU are concerned?
Well, the autumn will be the earliest possible date, and it might well be later than that, to be truth to tell. But I mean, the idea that you could do anything that required primary legislation first is out of the ball, and probably anything that you'd want to do this year, if you can do it by means of regulation, guidance, and so on, that is, I think, doable in a shorter time frame. But you're quite right; we're not going to see much else, unless there's an absolute emergency.
Right. Okay. Given the very sharp increase that we're seeing in the registration of new claims management companies, is government not concerned about the need to move more quickly? And the fact that parliamentary capacity is so constrained and there are so many pressing issues to be dealt with, we're heading for a perfect storm, aren't we?
You know, even back in 2010 when I was a minister, I could never remember when there wasn't a constraint on parliamentary time. And everybody said everything is urgent. And everybody said, you know, if we don't do this now, there will be a problem. And the truth is, sometimes it's the Angela Merkel approach. The problem moved on. I don't think that's going to happen in this case, but I do think there is a bit of that in there. I think probably the most important thing is to do with the immediate measures that we can at the moment. A very important issue that's going to come up in terms of what's happening in Parliament is going to be the July statement around financial measures. I think that's critical. And back to the enforcement point in that regard, I have a real concern, and many MPs have a real concern about the capacity of local authorities to enforce, to do that, because of the massive financial losses that they have incurred. I mean, you've got Manchester talking about a 166 million shortfall due to the drop in income. I've got sort of London councils talking across London of about 1.8 billion potentially going forward. Now, if that's the pressure on local authorities, I think that's going to be a real and immediate problem, because that will affect enforcement, but equally it's going to affect their ability to drive forward and simply deliver statutory responsibilities in a raft of other even more politically sensitive areas. So I think that if there's a real storm coming, it's around that sort of thing, and how we link that up with funding. The other important point about recovery in the care sector, which I think is going to be massively hit by all of this.
Henry, heard from Bob there about the pressure on local authorities in particular. Any points that you want to come back on in response to what's been said?
That's exactly it. Is it now half a dozen local authorities have given notice of the possibility that they can become insolvent? Local authorities have struggled through this crisis. They've done their best. Local authorities have redeployed workers. Anecdotally, one local authority for which I act sent its legal team out on the bins in the early days of the crisis because they had so many absentees. So from a practical point of view, they are at the front line of this. And because of the care homes point, and because of there's another point that links into this relating to children's social care, and that is, of course, that while social workers were having to socially distance, whilst vulnerable children were not at school, there has been a slippage in child protection. That will manifest itself in claims. So from that point of view, the local authorities not only face claims for what has gone on to now, but then are tasked with the business of trying to sort things out as best they can and enforce regulations and drive business forward in their own area. At the same time, as this feeds into the recessionary point and to the financial point, as businesses go bust, business rates will dry up and so forth. So from that point of view, local authorities also face an income hit. So as a result of that, local authorities are at the forefront of trying to solve the problem, but at the same time, they have quite a significant number of challenges of their own to deal with.
Okay, well, I'm conscious that we might have to say goodbye to Bob at 2 o'clock. He has parliamentary business, so I'm going to skip over a couple of questions that we had lined up to come to one that really has occupied many debates, many discussions, newspaper headlines in the last few weeks, and that is this. Whilst we talk about public confidence in the context of the insurance industry having been shaken in recent months, of course, for many people, a much more important issue is how government has handled the COVID-19 public health emergency, and in particular its impact not just on lives but also on livelihoods. A public inquiry is inevitable, surely, Bob Noon?
I'm okay. Yeah. Yeah. I think that's right, Ed. I mean, realistically, this is of such a magnitude that it's impossible to avoid that. And I don't think any sensible government would or could. Actually, the pressure will be too great. Interesting question about the formal inquiry takes. Is it going to be a statutory inquiry under the Inquiries Act, for example, or does it take some different form? That will be interesting. Points what we do then about who do we have involved in it, how do we gather the evidence, the time frame, and so forth. No, that's a really major issue, and I think that's inevitably going to happen as far as that's concerned. And again, part of the evidence around that will address a number of these issues that we picked up about that discharge into care homes. Something I've picked up again in my own constituency. Bromley's got the highest percentage of over 65s in Greater London, interestingly, and particularly high percentage of care homes, and that's been a real issue there. So I think those issues, raft of other stuff, but then you're going to have this economic versus the health. Can it be a trade-off? And how do you put that? How do you frame that really important discussion in terms which are acceptable to the public to take sufficient consent with you to go down the route that you need to do, but which equally does bring home the sort of the hard economic realities. And if you want a world-class health and social care services, you've got to have a world-class economy to pay for it, and that's the wretched dilemma. I think a few people are sort of scratching their heads on both sides as far as that's concerned, and that's going to be a real issue. But it certainly will be there. Yeah, I'm sorry, I have to drop out just after 2. Ironically, I've got a conference call with would you believe the Lord Chancellor. It's not actually about this, but you can't say that Wakeman's aren't on the money. It's actually about a different piece of legislation entirely. But I promise I and others will have the opportunity to raise some of these points, particularly around civil justice reform and where we are going around some of those things. As I say, do bash away to your own MP, because the problem I find is this: the civil service has many strengths, and it's good at delivering policy advice, but central civil service is not essentially about service delivery in many areas. And local government world is much more. So getting as much practical example, the people who drew up the regs, I'm sure will have consulted with all the usual trade organisations and bodies, but things do get missed in that. And I think that's where both the white paper that you're going to produce, Ed, and also the individual lobbying power, never underestimate that, particularly in areas where you've got quite a lot of new MPs came in at the last election, I just say it gently, and some of them have got small majorities, some of them have probably represent seats that weren't represented by that party for a long time, and so there is a genuine point, and actually, in fact, most of them very proactive locally as well. Do engage as businesses with your member of parliament, and I've been having a vast amount of contact with my local businesses. Do take up that opportunity and try and get that messages through, because the policy formulation process doesn't always get that sort of, for want of a better word, client input into it in the way that perhaps user input in the way that one would ideally like. So that's an important message from today, Ed.
Oh, let me ask you this then, because you're suggesting that representations are made. I mean, it seems to me, and correct me if I'm wrong, but the pressure concerning the public inquiry, sort of the constituency voice, it's going to be used as a platform, isn't it, also for nationalist agendas? I mean, we're going to see a lot of pressure from the devolved governments in Wales and Scotland, I would have thought.
Yeah, I think that's certainly true, and the big issue there politically is what happens with Scotland, because I mean there is no doubt, not being trying to be non-partisan on this, but there's no doubt that Nicola Sturgeon is looking for any excuse, any opportunity to push a separatist agenda, as I will characterise it. And if the consequences of this play in their hands in that way, then that's something I'm sure they will do. SNP isn't without its other domestic problems, mind. And they might want to see some distractions there. I think Wales, yes, to a degree. I think the pressure is slightly different in Wales. I think the Welsh Assembly government, Mark Drake, had perhaps the easiest time over all of this. And they've got some, again, domestic issues around the performance of their health service and so on. That may slightly change the political rhetoric there. But it's certainly going to be one of the involvement of the devolved administrations has been something in particular Scots and Nats MPs in Parliament have been banging on about repeatedly, and that's clearly not a coincidence.
Okay. You touched on form of inquiry, Bob. Mark, I'm going to come to you. Form of inquiry, will it involve insurers?
So, I mean, I think first of all, we're still, clearly we're still in the midst of a pandemic with daily reports of hundreds of lives being lost. So the priority still needs to remain on public health. That said, I wouldn't argue with or against the public inquiry being inevitable. I think it's probably just a bit too early to speculate about what form that may take. I am sure insurance will be looked at as part of the lessons learned, whether this be by the FCA or more widely. Our role as insurers is much more focused on the economy and helping businesses and families rather than public health. And there will undoubtedly be a need for further discussions on, the public policy challenges that this crisis has brought about and how we best as a society and as an economy cope with the risks of pandemics and indeed wider systemic risks. This isn't just necessarily going to be about COVID-19 or about infectious and communicable disease. You can easily see how this translates across to cyber risk, to other risks, and how that model and partnership between government and the insurance industry should work in that going forward. And we at the ABI will play our part in that, undoubtedly.
You make a very important point there, and it's one that came up in question time one actually, and I remember questioning you about this, Bob, that the national strategy document produced back in 2010 cited terrorism, cyber, and pandemic as the key risks that the nation needed to focus upon. Sadly, pandemic slipped off the radar, and we went forward with cyber and terrorism. Is there a new intent on the part of government to redress that balance going forward? And are there any other systemic risks that are potentially hoving into view as far as discussions at a government cabinet level are concerned?
Well, I mean, government obviously pretty careful about what they share in relation to those matters, as you can imagine. But there is no doubt that the risk that was identified, a pandemic, and particularly the way that was seen almost entirely operationally, I think, in terms of influenza type pandemic rather than the COVID, is something that's an issue that's going to have to be looked at. The National Security Strategy Scrutiny Committee, it's a joint committee of both houses, which, as it happens, I serve on as chairman of the Justice Committee, and a number of others, is beginning to look at the revisions to the strategy and follow-ups. So I think you'll be seeing quite a bit of evidence in Parliament coming forward. Actually, may be interesting to those who particularly work in this field around precisely those sort of areas. So and no doubt the government therefore will want to have responses and answers around a lot of that. So that actually is becoming to be a bit much busier space than it has been for a time.
Okay, Bob, just conscious of the time, have we got you for a couple more minutes? Because we've had
a couple more minutes and that's up. Yeah.
Great. So we've had lots of questions pouring in from the audience. I'm going to come on to some of those. A team behind the scenes has been trying to pull together the most similar questions, and we've got a set here. So the first one, which I'm going to raise, and I'm going to come to you, Bob, to Dowie, and to Deborah on this, is as follows. So talk has moved from react, respond to recovery, rebuild. But how different do the panel think rebuild will look like for insurance, and what impact is a second wave likely to have on that?
I'd sort of, on the insurance point, I think I'd defer to Dowie on that. On my point, because I probably am going to have to disappear. I see I'm getting messages at the moment. I think could be very profound. It's going to, I think, change a raft of areas in which we think the way in which markets operate. I think it actually may well change the public perception and therefore the political debate around the role of the state as a sort of a guarantor in both social and to some degree economic terms. I think that could make quite an interesting development around that, and that brings you back into some of these things about redress and who stands behind who under these circumstances. Ed?
I mean, do you envisage? I mean, publicly, a crisis of confidence would emerge in government if there was to be a widespread second wave and another national lockdown.
Yeah, absolutely.
To an extent that Boris and the cabinet couldn't recover, do you think?
I think it would be exceedingly damaging for any government that was in power if there were to be a second wave, particularly if it's one where we had not manifestly learnt the lessons of the first one. And that's why what we've been talking about at the employer level about taking steps to protect yourself is important for us as a government and societally as well. That will be hugely damaging as well as economically damaging. And I've no doubt that is also why some of these longer term issues, the inquiry and other things that we were talking about, longer term legislative changes, while they will happen, aren't going to be something that's done immediately, because the absolute focus is now A, trying to get a new normality going, but B, having that plan B to deal with the second spike. And you could imagine everything else being put on hold if need be, but they, as I said before, they'll be reluctant to go back to the blanket lockdown because of the economic costs. You know, we're running, as you know, at a high level now of public debt than the country hardly borrowing we've ever had outside wartime, and that's not sustainable. But we're dealing with unprecedented pressures that may yet come along.
And you say everything else would be put on hold if we had a second spike, including Brexit?
Well, you and I might be tempted by that, Ed. You know, I think everybody knows that Brexit wasn't the side that I favoured during the referendum. That may be harder to achieve, I have to say. Equally, I'd add the only thing that's just to add to that is, if that's a pressure on us, it's also a pressure on our EU friends as well, because I mean, obviously they have the same domestic pressures to varying degrees, it should be said, out of the pandemic as well. I would hope, being an optimist, because I'm a West Ham supporter, so I have to be, that I would hope it might actually drive a bit of pragmatism on both sides to get the deal by the due date, but one that involves a bit of give and take. But, you know, hey, the way my football team's going at the moment, I'm not going to put absolute bets on it. So, on that cheerful note, I hope you'll forgive me if I go about my other duties, but it's been really useful, can I say, Ed? Very helpful to me, actually, and I hope it's been helpful to everybody that's joined in.
No, I think I speak for us all and the audience. We say it's been really great to have your insights, Bob. So thank you for joining us today. We will push on. We're finishing at 2, but hopefully, if we can get some of your insights for the white paper too, that'd be great. Thank you very much. Okay, so some practical applications, obviously, from this question too, from both the regulatory and a claims perspective, and we want to try and get some more practical help, guidance to businesses tackling this question. Deborah, can I come to you? Hopefully, we've got you on with sound now. Rebuild in wave. You know, for businesses, this is got to be a key concern, doesn't it?
I think it does, yeah. Sorry, can everybody hear me?
No, the sound. There's a delay on the sound. Tell you what, let's see if we can sort it. Dowie, I'll come to you. We'll deal with the regulatory point rather than the claims point first, if we may.
Sure, thanks, Ed. So as we move into rebuild, recover, there will be the soft landing I spoke about with HSE being hands off whilst businesses learn, and there's sympathy for businesses. As that period progresses through rebuild, recover, if that sympathy and that learning opportunity goes and the hands off approach from HSE goes, so the liability for the employer, the duty holder, increases. So there'll be far less margin for error, far fewer opportunities to say, well, we're still learning. We can only say that for so long. And if, heaven forbid, we hit a second wave or a second spike, then all bets are off and we start again, because something has gone wrong. And that might be the way in which we return to work, either in the main or in part. And so we will again revisit what COVID secure in the workplace looks like. And if that cannot be achieved, we might have to go back to another total lockdown. And that clearly is a huge concern.
Great. So next question from the audience. How do you see the post-COVID-19 and post-Brexit world impacting on claims against local authorities? And how do you think the insurance market will react to this? Henry and Mark, this looks like a question right up your respective streets. I'm going to come to you first, Henry, if I may.
The post-COVID world claims against local authorities have always been treated as sort of the last resort for claims, so that they're always there. The reality of them is that they have to be financially supported even if they become insolvent. So that the reality is that they are a defendant that will effectively always be with us. The other thing about local authorities is that because of the myriad of statutory duties they have and because of the Human Rights Act, they become a relatively straightforward target in the perception of claimant representatives. And I think one of the things that is worth looking at, links in with what Bob was saying about inquiries, is that there will be inquiries into COVID-19 and deaths from it starting now. They'll be starting now in the form of inquests. Although the Chief Coroner has indicated that COVID-19 is a natural cause of death and therefore doesn't automatically mean an inquest, the reality of it is that a care home death in particular, I'm sorry to keep emphasising this, but this is a specific area that is clearly identifiable. A care home death will give the appearance of being caused potentially by a lack of care in some way, shape, or form. That makes it something that a coroner will look at, and that means that we will get many public inquiries starting in the form of inquests starting right now. And we're aware of 3 opened and adjourned COVID inquests already. That activity will increase, and it's inevitable that the local authorities involved in that will be interested parties. That immediately makes them part of the debate, and as soon as they're part of the debate, out come the claimant representatives. As to the effect of Brexit, I'm afraid that's way off my pay scale to work out precisely what will come of that. I'm afraid I have no idea, and I think it would be silly for me to speculate.
Fair enough. I mean, I think none of us have a crystal ball. Mark, I'm going to come to you. So, insurance market response. It's been a torrid few months because of business interruption. Reputational issues abound. The insurance market isn't going to want to shy away, is it?
I think your assessment is right. It's not been a reputationally the insurance moment's finest, or far from it. And there will be a need to reflect on that and learn some of the lessons from that. I think from the business interruption angle, there's been a real difficulty, clearly, given the difference in perception around what is covered. So the perception from businesses that they would and should have been covered for an interruption of this kind, and the perception from the vast majority of the insurance market that most policies did not cover an interruption of this kind. And marrying those two up, is really difficult, and if not impossible, because they're at polar opposites of the spectrum. We'll see what happens with the FCA process, but I think more broadly, in terms of reputation, there is a real need, I think, to start speaking again about the value of insurance outside of this crisis. There's a real risk of the skepticism about the value of insurance products now and what they're there for and what they deliver for. So there's a real need, I think, to lean into that and make sure that the value of insurance is well understood and the point of insurance is well understood. I think that there's clearly an issue about working with government around how do you ensure, or what model do you use to cover pandemics or risks of this kind in the future, and how does that work, and to what extent is insurance involved, or is government taking the share of that risk. And then I think, more broadly, that there is just the issue really of insurers needing to adapt to the changing demands of customers, and the demands and needs of customers are going to change. Insurers will need to be flexible and think about the products that they're offering, and that they're meeting those demands and needs of customers where possible. And clearly, as part of that, that involves I think a much better communication process, a much better understanding between carriers, brokers, and customers, and around doing some kind of innovative thinking around where is a risk transfer mechanism an appropriate model to cover this risk, or where is it something else? Where does the risk transfer mechanism as a kind of fundamental philosophy not stand up, and therefore do we need to think about other models? But I mean, you're right, the insurance industry has been around for over 300 years. It's, you know, it is innovative, and I'm sure it will still remain vital to sectors across the economy.
That's great, thank you, Mark. I think we've got time for just one, maybe two more, but really, really quickly. So next one, can I ask for thoughts on document retention in relation to potential COVID claims that we may receive? Our current guidance for EL claims is to keep any evidence for 3 years and 4 months. Is there anything to suggest we should increase this timeline for COVID claims? And if so, how long to? Henry, can I come to you on this?
Very short answer, yes, increase your time. What will happen is the pandemic will end, then claims management companies will start trying to hoover up the claims. Then as 3 years approaches, we will arrive at a point just like we've had with PPI claims, where everyone is trying to get the last ones in before the limitation date. If you are running at 3 years and 4 months, you will be dangerously close to those last claims coming in after you've destroyed documents. So I think I would put another year on that if it were me.
So 4 years, 4 months is where you're sticking your flag in the sand.
I'm a lawyer. 25 years is what I would like to see, because we like documents. But in terms of businesses having to operate in a real world, 4 or 5 years strikes me as right. Very
good, thank you. And then finally, as pubs and other social venues look to reopen, to what extent are operators entitled to rely on their customers' knowledge of and compliance with the widely publicised government guidelines and social distancing rules to protect themselves and other members of the public? Or do the operators have a duty to go further in actively enforcing the safety measures being put in place? Dawiat Thomas, I'm going to come to you on this one first, if I may.
So from an enforcement perspective, I think if the duty holder, the employer, has put in place reasonable measures and can document and show the enforcer, whether that's the police, if it's a pub that's spilled out onto the road, or a local authority officer, or the health and safety executive, if it's an employee related issue. I think if they can show that they've taken a reasonable stance and reasonable measures, and actually it's the conduct of their customers, that is the weak point. I think the sympathy will be with the duty holder, and the attention should then turn to those individuals who are flouting what we all know in terms of social distancing, but specifically that organisation's control measures. So I think that's where that sort of situation will turn to. It will deflect away from the duty holder and onto those who are breaching the rules.
And the same presumably in terms of duty of care under the common law, Henry?
That's more nuanced. It's a more complicated question, because what you're talking about in common law would be holding the publican or the shop owner liable for the acts of their customers. That is a very difficult area of the law of negligence. There is some case law around nightclubs failing to protect people from incidents of violence. The more classic example of an occupier who accepts a safety duty would be the swimming pool that provides a lifeguard. Those types of things, or the school where teachers keep an eye on playtime. But the reality of it is that customers in a shop, I don't think, will be viewed by the courts as vulnerable as children in a playground or swimmers in the deep end of the swimming bath and what have you. That is a very difficult area of law, and I would expect to see a lot of challenge around that. I mean, the starting point of representing a local authority, who was accused of fault for not keeping everybody 2 meters apart within a leisure centre, my starting point would be quite optimistic about my chances on that, because there comes a point where occupiers are not liable for the acts of third parties, of adult third parties, and that's extremely that's an important line of case law that we need to preserve.
Okay, actually, final one, and I want to give this one to Mark so that the industry has the last word in this debate, if I may. And the question that's posed is this. I think that the insurers have let everyone down. People pay a lot of money for insurance. COVID-19 should have been covered. What is the insurance industry doing to help people during this COVID-19 pandemic?
Yeah, Ed, so I mean, I completely appreciate the sentiment behind the question and the strength of feeling behind the question. You know, the ABI's postbag has been full of very similar sentiments, and I think we're very aware of what the the feeling is about the industry at the moment. As I said before, I think that is a result of, for whatever reason, businesses having an understanding that they would be covered for this interruption and insurers disagreeing with that. Now, the FCA process may result in an outcome that changes that going forward. But I think the most important thing for us is to concentrate on the principles and value of insurance to customers again, and on working through the most appropriate model to be able to cover against the types of risks that we are seeing more and more in modern day society, and that insurers want us to protect them against. Sometimes when those are systemic or extremely high cost, they can be really difficult for an insurer's balance sheet to cover and for a market to provide for. But that's when we need to have some innovative thinking around how does that partnership work with other sectors of government, and how do we as a society help protect the economy against those risks going forward. That's a public policy challenge that insurers need to be a part of, but aren't necessarily the full answer for.
Fantastic. Well, I would invite Bob Neal back on this if he was with us, but he's not for the present time. So we will pick this point up very, very clearly in the white paper when we produce it. And so let me say at this point, thank you very much indeed for joining with us today. Thank you to our panelists also. We hope that you've enjoyed the debate. If you have any questions that you would like us to answer that we didn't get the chance to answer during the session, please email those in via the Coronavirus Hub on the Wakeman's website. And in the meantime, as I say, a white paper on its way to you very shortly, where we'll bring all of the threads, all of the perspectives you've heard today together in one place. Thank you very much. Have a safe afternoon. Keep well. Thank you.